I'd like to welcome today's speaker, Michael Joyce. Michael is with the firm Master and Good. Michael counsels companies and compensation committees on executives in a range of executive compensation matters, including employment separation and separation agreements. He also counsels companies on all aspects of employer-provided benefits. Prior to joining Master Good, Michael was with the firm in Chicago, and he received his JD from University of Iowa. I'm going to turn it over to Michael. I've got the question area for you.
Hi, good afternoon, and welcome to today's presentation. I appreciate your being here, and I appreciate the Iowa State Bar inviting me to talk today on Internal Revenue Code Section 409A and non-qualified deferred compensation. Christy gave a little bit about my background. Just to add a little more, I've been at the Master Good Law Firm for about 4 years now. For me, this was a homecoming, returning home to Iowa and to Des Moines, so I was pleased to get back to Master. Master also has offices in the Cedar Rapids and Ames, in Cedar Rapids and Ames. Before Master, I was at a firm in Chicago, and before going back to law school, I had been at large accounting firms also working in the employee benefits field. So I'm getting close to 20 years probably working in the employee benefits arena, the last 11, 12 or so as a lawyer. Specifically, my practice, it's employee benefits. That could range from qualified retirement plans to non-qualified retirement plans that we're going to talk about today. Health and welfare issues, including health care reform or the ACA. I expect there's going to be some changes in the ACA coming soon, or maybe removal of the ACA, depending on what happens with the new presidential administration. But today we will discuss non-qualified deferred comp, and the title is Comprehending Code Section 409A, and I think that's appropriate. This was a very large statute that came into effect in 2005. Before that, non-qualified deferred compensation didn't have the same type of rules surrounding it. So with that, let's dig into it a little deeper here. Okay. Code Section 409A regulates non-qualified deferred compensation. We'll describe that a little more in another slide. It was enacted effective January 1, 2005, and the statute arose in reaction to certain corporate abuses of non-qualified plans. In particular, I'm thinking of Enron. Around the turn of the century, Enron was going under. A number of executives pulled money out of their non-qualified deferred comp plans, or were able to terminate employment, whatever the circumstance, get their money out of the non-qualified deferred comp plan before Enron declared bankruptcy. And part of the structure, which we'll discuss, of non-qualified deferred comp is that those funds are subject to the creditors. So after that happened, there was a reaction to that. We need more rules surrounding deferred compensation. So that's how 409A arose. It took a few years, but then 409A came into effect, and probably the biggest surprise about 409A was that, yes, it dealt with traditional retirement type non-qualified deferred comp, but it also expanded kind of the thinking of what constitutes deferred comp and became much broader to think of things like bonus and incentive programs or separation pay. The big stick, so to speak, to enforce 409A is a 20% penalty tax on the amount involved, and that's imposed against the individual. It's not necessarily a penalty against the employer. We have not seen a lot of penalties imposed in this area so far, but usually it's thought that the individual, the participant, would probably try to get that money back from the employer if this penalty is imposed. The final regulations took a couple years. They came out in 2007, and then another couple years, a year and a half was given to get comfortable or get familiar with those regulations. They came into effect in January 1, 2009. There were just additional proposed regulations issued in June of this year. I won't really talk about those much. I'm dealing more with the fundamentals of Section 409A, but those proposed regulations, more of a clarification nature, gave some information, clarified a number of things, generally favorable to practitioners and to companies with respect to 409A. Doesn't necessarily affect the fundamentals we'll discuss today. Okay, moving on. Before we get into Section 409A and how it affects non-qualified plans, let's step back a little bit and look at what is a non-qualified plan, and if we have non-qualified, what's a qualified plan? Well, these are terms from under the Internal Revenue Code, and a qualified plan is a retirement plan that meets the requirements of Code Section 401A. A non-qualified plan is a retirement plan that does not qualify under Section 401A. So I'm sure that's very helpful to you, but to put a little more color there, a qualified plan, probably the easiest example is a 401k plan, which many employers sponsor for their employees. And that is a plan, or it could be something like a pension plan, which are becoming less and less common, frankly, these days. But a qualified plan is intended to provide a broad benefits to a broad scope of employees. And with that comes some very good tax benefits to those plans. With those tax benefits come a significant number of tax rules. As an example of those kind of the tax rules related to a qualified plan, and kind of help put non-qualified plans into perspective. With just a typical tax situation, the employer pays compensation to the employee. Employer gets a compensation expense deduction on its taxes. Employee recognizes those amounts as income and pays taxes on those amounts. So there's a balance between compensation expense deduction for employer and taxation on those amounts by the employee. With a qualified retirement plan, a trust is established. The employer contributes to that trust, the retirement plan funds into that trust. Employer gets an compensation expense deduction at that time of contribution. However, the employee does not get taxed on those amounts until some later date. So there's a delay between the employer's deduction and the employees recognizing those amounts as in taxable income. So that's a qualified plan. What's non-qualified? Well, that's a much narrower plan, typically for executives, the highly compensated employees of the company. But the key, going along with this tax distinction, the employer does not get a deduction until those funds are actually paid out to the employee at some later date, even if the employee is vested in those amounts. So let's look at that a little more closely. Excuse me. What is non-qualified deferred comp? They are unfunded non-qualified deferred comp programs. They've been around for years. Unfunded just means that there's no separate trust set up. Usually the funds stay as part of the general assets of the employer. There's a lot more flexibility in the plan design and structure of these plans than there are for qualified retirement plans. Generally, these plans are only for upper management and highly compensated employees. Non-qualified plans are traditionally viewed as a type of retirement program or a supplement for executives. So in addition to those qualified plans, which are limited in how much can be contributed or the benefits that can be earned under those plans on a year-to-year basis. And I mentioned this before, the income tax is deferred until the amounts are actually paid out to the participant. But I would make this point, while income tax is deferred on the non-qualified benefits, as soon as those amounts are vested, employment tax applies. Social Security, Medicare tax will apply at the time of vesting. This is sometimes missed by employers. This isn't across the board. It depends on what type of non-qualified arrangement it is. But an account balance plan, typically where an employee is building up a specific balance in their non-qualified account, when those amounts are vested, then the employment taxes apply. Often, the employees that participate in these plans are highly compensated. Their wages are often getting above the Social Security wage base, so the Medicare tax may be the only tax that applies in the end. But just to identify that if you're dealing with these programs. Okay, continuing with kind of the question, well, what's non-qualified deferred comp? It's an amount to which and this comes out of Section 409A, it's an amount to which the individual has a current legally binding right, but it's not going to be paid until a later year. As I mentioned before, 409A kind of really exploded what was considered deferred compensation when it was introduced in 2005. So it wasn't just, amounts set aside for executives for retirement, things like that. It could pick up, bonuses, long-term incentive programs, severance amounts. So it really did expand what was considered deferred comp. Now, just to close out the general idea, though, traditionally we think of deferred compensation, non-qualified deferred comp, as retirement compensation. So here's just kind of a few last highlights of deferred comp to kind of set the stage here before we dig closer into 409A. So what are the keys for particularly retirement non-qualified deferred comp? Limited participation. There is a term of a top hat plan. That comes out of ERISA. This will pretty much be the only time I mention ERISA, the Employee Retirement Income Security Act of 1974. ERISA gets involved in the regulation of both retirement benefits and health and welfare benefits of employees. In the case of non-qualified deferred compensation, ERISA could have there could be an effect of ERISA on those benefits, but there's something called a top hat exemption, which exempts these non-qualified plans from most of the ERISA requirements. Again, top hat is a select group of management or highly compensated employees. So if you have this type of non-qualified plan, that's what we're discussing today, then when it's created, very soon after its creation, you must submit a filing to the Department of Labor, this top hat filing, to identify the plan, and then it pulls you out or pulls this plan out of most of the ERISA requirements. Next bullet, no early tax benefit for the employer. I mentioned that earlier. The employer deduction occurs not until the employee is actually paid those funds and is taxed on those funds. Unlike a qualified retirement plan where the funds are contributed into this separate trust where the employer can no longer touch those funds and the participant is restricted in how and when he or she can access those funds, unlike a qualified plan, the money in a non-qualified plan has to be at risk, and that is done by the structure of the funds remaining subject to the creditors of the employer. The funds can't be held in the trust. Most of the time, these funds are held in the general assets of the employer. It might be funded in the sense that funds are set aside to pay these costs. In some cases, the employer makes no set aside to account for these non-qualified benefits. But there is one circumstance, I've noted it here. Funds can't be held in a trust, but there is something called a rabbi trust that you may have heard of. Rabbi trusts are allowed. It's basically as far as you can go in segregating the assets from the employer's general assets without making those funds taxable to the employee. A rabbi trust is so named because the first one approved by the IRS was for a rabbi, for retirement arrangement set up for a rabbi. And basically, the funds are put into a separate account, but they still must be available to the creditors of the company. If the company were to become insolvent, go bankrupt, those funds would then become accessible to the creditors. Otherwise, the company cannot access those funds for its own general purposes. So, with a non-qualified plan, the benefits are not limited as in a qualified plan. In your employer's 401k plan, you're limited to $17,500 or $18,000 this year and what you can defer into that plan, whereas the amounts can be much greater in a non-qualified plan, and that's why they're attractive to companies that want to incentivize the executives. Finally, since 2005 or a little later when those regulations came in, non-qualified plans must comply with Section 409A. So getting more specifically into the requirements of Section 409A, one basic requirement, the plan must be written. There were times in the past when plans, there were just arrangements, they were kind of informal arrangements, but now all the provisions must be written down in a plan document. The amount deferred under the program must be specified. If it's an employer amount being contributed to the plan, then it could be a specific amount, or it has to be, it could be a specific amount of money. $50,000 is contributed on behalf of participant A, or it could be, 5% of participant A's annual compensation for 2016 will be contributed, or it could be something like a formula. Perhaps even in our executive bonus program, we're funding that plan with 5% of the net income of 2016. So that works as well, but in any case, you have to be able to get to a specific number at some point to identify what has been deferred into the program. It's similar if there are participant elections. The participant has to be able to specify what that amount is, whether it's a percentage or a specific dollar amount. The payment event has to be specified or elected prior to the time of making the deferral election. We'll go into these points more as we go along here. And the violation, it's immediate taxation on the amounts involved plus a 20% penalty tax. So just a kind of big picture, identify what is deferred, specify when the payment is to occur, when that deferred comp will be paid out, and then pay those amounts when specified. Okay, looking a little more closely at participant elections, excuse me. Okay, first of all, I mentioned that the plan must be written. So a plan doesn't necessarily even have to offer, a deferred comp plan doesn't have to offer a participant election. It depends on the terms of the plan. If it's a more traditional non-qualified deferred comp plan, yeah, then it probably has a participant deferral election as part of the benefits. So, number one, it depends on the plan terms. Second, the participant has to make that election by the end of the year, by December 31, prior to the year that amounts are supposed to be earned. As I mentioned before, you got to specify that amount. But as an example, if you're deferring salary from 2017, well, that election has to be made by the December 31 of 2016. Now, there are some exceptions here that I don't mention in the slides here, but such as performance-based pay, where the participant may have a little more time to make that election. But the general rule is you must make the election before the amount is earned, in the year before the amount is earned. That is different than, say, a 401k plan where a participant can change elections throughout the year for future compensation. Also at this time of the deferral election, the participant must elect the time and form of payment. So what would be a typical time of payment? Well, that could be separation from service, otherwise referred to termination of employment or retirement. It could also be a specified age, at age 60, pay me my amounts, or a specific date, July 15th of 2020. Again, this goes back to the terms of the plan. The plan will tell you, it may only say, the plan may dictate you will be paid out on a separation from service. But these are the typical provisions that would be in the plan, and if there is a choice, these would be the typical choices. The typical form of payment is either a lump sum or installment payments depends on the time. I usually don't see more than a 10-year installment period, something closer to 3 to 5. But again, that would have to be provided in the plan. If it says payments are made in a lump sum, well then that's the way it'll be paid. If it gives an election, well then the participant can have an election. Subsequent election can occur later. I'll talk a little bit more about that shortly. Okay. So one of the big changes with Section 409A, it was very concerned with payment of deferred comp. As I kind of italicized before, say when you're going to pay it and pay it at that time. There can't be any acceleration of payment. There's a few exceptions, but the general rule is no acceleration of payment. So these were the 6 payment events that were set out and specified by Section 409A. We'll go through each of these, but just a few comments here. A plan can offer just one of these payment events, or it may offer several of the payment events. And also payment could be structure. If there's 2 payment events, it might be an earlier of structure or a later of structure. Say the deferred compensation will pay out on the earlier of separation from service, or July 15 of 2025. Or it could be reversed in that the deferred compensation will pay out on the later of separation from service, or July 15th, 2025. So there are a number of ways this can be structured. The key is, though, you've got to fit within the structure of these payment events here. So let's talk about these payment events in a little more detail. The first 2 are the most common. Specified time or fixed schedule. So this would be either a date or it could be an age, but identifying, like my example, July 15, 2025 will be the payment date. Or if it's a fixed schedule, maybe it's paid out in installments, payments will commence July 15th, 2025 in 3 equal annual installments. continuing in July of 2026 and July of 2027. So that's the specified time or fixed schedule, and that could include specifying an age too. The next one is separation from service. I mentioned this term separation from service before. It doesn't just say termination of employment. That is because Code Section 409A has greater applicability than just to employees. It could also apply to directors or independent contractors. I'm pretty much only discussing this from an employee context, but to make you aware, it can also have application to particularly director arrangements and other independent contractor arrangements. So anyway, separation from service, it's termination of employment. There are rules to protect against sham terminations. I guess the thing I'd like to identify here is that separation from service or termination of employment seems like a pretty easy concept, and generally it is. But there was concern with the regulators when they put these regulations in place that people could play with the idea of a termination of employment in order to get to their money sooner. Say an employee, an executive leaves employment but then starts a consulting relationship with a company. To protect against these potential abuses, the regulations do provide rules that address, well, what really constitutes a termination of employment or a separation from service. So there are rules such as a specific, let's say it's not uncommon for an executive to take a reduced role with a company after being employed full-time for many years. But there's guidelines, say a safe harbor, where if the employee works less than 20% of his or her average hours over the prior 3 years, well, then that will be considered a safe harbor where the person is considered separated, even though there's still some level of service provided to the company. If it's in a range of, say 20 to 40%, well, then that's a facts and circumstances analysis. If it's above that, well, it's still facts and circumstances analysis, but there's a presumption that there has been no separation from service. So the key here is that typically that's pretty straightforward, but there are rules to help protect against fraudulent transactions where someone may want to get to that money but not fully terminate his or her employment. The next payment event is death. I think that one's fairly self-explanatory. The following one is disability. There is a strict definition in the 409A regulations of disability, and it's basically any mental or physical impairment that is expected to result in death or last for longer than 12 months. There's another one where there could also be disability payments being made, but still a similar threshold of the condition that's expected to result in death or last for greater than 12 months. One note about disability, it can be a payment event under Section 409A. However, in most cases we don't see that. That may be some type of a triggering event, say for vesting of the benefit, things like that. That usually isn't the payment event in the deferred comp arrangements I put together. Still, payment is tied to the person's separation from service. However, disability, if it is a payment event itself, then it has to meet the strict definition of Section 409A. If not, you could define disability differently, but then you would have a different payment event, such as separation from service. The next one is change in control. Change in control of the company. Similar to disability, there are specific definitions in 409A related to a change in control. They deal with a sale of the company stock, could be a merger, could be a sale of assets, or even a hostile takeover of the board. Directors coming onto the board without being approved by the existing directors. These can all be change in control events that could trigger a payment if your plan provides for that. The point here is that there are specific definitions in the 409A regulations of what constitutes a change in control. When providing that as a payment event, note that, like, for example, if a sale of assets is a triggering event, well, the regulations say, well, that could be triggered by a sale of 40% or more of the assets of the company. Well, in a lot of practitioners' minds, that's a very low threshold for a sale of assets. Might be something closer to 80%, substantially all of the assets of the company would be sold. Well, in designing these programs, you have complete discretion to elevate that threshold to 80% or to say substantially all of the assets, something like that. The key is, however, that you at least have to meet the standards in Section 409A, and either you meet them or you exceed them. The last one is unforeseeable emergency. This is one case where you can build into the plan, and it doesn't necessarily have to be at the time the plan is adopted. It could be added later. But an unforeseeable emergency could be a situation where the executive does get payment earlier than otherwise provided under the plan. But again, there are specific descriptions of what would constitute an unforeseeable emergency and be a valid payment event. It could be a severe financial hardship resulting from illness, or an accident to the participant or to the participant's family. It could be a severe casualty loss, or other extraordinary circumstances outside the control of the participant. So the point, I don't see all that often, the unforeseeable emergency payment trigger, but it is available. Okay, I mentioned earlier a subsequent deferral or a subsequent deferral election. As I mentioned, 409A is very concerned, it's very concerned with the payments being made when the plan says the payments are going to be made, or when the participant elected. Well, this is one case, so long as it's provided, this option is provided under the plan document, it has to be written in there, where the participant could make a subsequent deferral election in order to delay that payment. But in order to do this, there are some strict conditions set around making this deferral election. The first one is that the election cannot take effect for 12 months. So this would be, for example, in the case of a separation from service or a termination of employment, payment occurs on termination. Well, if that's the case and the participant thinks, I'm gonna retire in February, but I don't necessarily need or want my deferred comp money yet, so let me delay that election 5 years down the road. Well, if it's November now and the participant will retire in February, it's too late to make that election, or the election will not go into effect. The IRS doesn't want you playing with the timing of the payment that close to when the actual payment's supposed to happen. So if you made that election today, for example, well, you wouldn't want to retire before November 11th or December 1st of 2017. So first of all, you've got to make the election or it can't take effect for 12 months. Second, the payment must be deferred at least 5 years from the original payment timing. To give some examples of that, if the payment is made on a separation from service, well, if that's the original election, then you would have to defer the payment at least until 5 years after separation from service. If payment is to be made at age 55, well, then payment would have to be delayed until at least age 60 or later. Or I guess there's also, if it's on a specific date in 2025, well, it would have to be delayed until 2030. The last one here, election to defer until a later specified time, must be made at least 12 months before the originally scheduled payment. So this comes more into play when payment is to be at a specified time. If payment is set to occur January 1 of 2018, well then I better make my election to delay that payment by the end of this year, by the end of 2016, so that that election is made at least 12 months before. Again, the IRS was concerned about manipulation too close to when those amounts would otherwise be brought into income. Okay, now we're going to shift. Well, many of those kind of features I talked about before apply to deferred comp generally. They're more often in the context of retirement deferred compensation. But now we'll get into some of those broader forms of deferred compensation expanded by Section 409A. That will include stock options, certain bonuses and long-term incentives, and separation pay. The other thing I will talk about, while 409A expanded what is considered deferred compensation, it also provided some pretty large exemptions or exceptions to what would constitute deferred comp, or ways to get you out of the regulation of the statute. And some of those exemptions we'll talk about more are restricted stock or equity, short-term deferrals, and involuntary separation pay, which can also be referred to as the 2 times rule. Okay, we're going to start with stock options. Okay, as the basic foundation or premise, stock options are subject to Section 409A, but there's a big exemption provided and a number of rules related to that. But just first specifically, well, what would it mean if a stock option were subject to 409A? A stock option, the beauty of it is, employee is granted the option. It's an option to exercise on a certain number of shares of stock at a certain price, and the employee has the ability to watch the stock price over the next 5, 7, 10 years, whatever the term of that option is, has the ability to watch the stock and then decide at some later time and say, yep, I'm going to exercise now when the stock is at this price. So the IRS looked at this and said, well, wait a second. The employee can look at the value of the stock and see if the option's gone up or not, and can basically exercise at any time he or she wants. It's like having money right in front of you. They could just take that money if they want, or take that into income. So the IRS considered stock options to be deferred compensation. But this is a long-standing compensation device. They recognized that and said, okay, well, we're going to set some rules around this to make it exempt from 409A. Still allow these to function as they have more or less in the past. But what are some of these rules for the exemption? At the time of grant, the exercise price must be set at the fair market value of the stock or greater, but no less than the fair market value. Second, the option has to be subject to tax per Code Section 83, but it has to be subject to tax at the time of exercise, the difference between the current fair market value of the share and the exercise price. That difference is subject to tax at the time of exercise. And this ties into, there can be no feature other than that discretion of the timing to exercise. There can be no other feature for the deferral of income. So you can't say at the time of exercise or sometime before that, say, yeah, I'll exercise now, but I want to defer that income until a later date. You have to recognize that income at the time of exercise. There are some other rules too. Only the stock of the employer can be used for the stock option to be exempt from 409A, or it could be possibly a parent or subsidiary company. There's a maximum 10-year option term. And then dividends or dividend equivalent rights cannot be tied to the exercise of the option. So the idea here is that, yeah, I have an option to exercise on 100 shares. I can do that over the next 7 years, or I have that choice over the next 7 years. But in the meantime, there might be dividends accumulating on those shares. And it's possible that the option award could provide for a right to those dividends on those awards. Well, the IRS looked at this and said, okay, you can still have dividend equivalent rights, but you can't delay that until the time of exercise, because in effect, if the exercise price is $5 a share or $10 a share, and over the period of time the dividends have accumulated to be $2 or $3 a share, well, you've basically or effectively reduced the exercise price from $10 a share to $7 a share based on those dividends. So what the IRS said is you cannot link the dividend equivalent rights or those dividends to the exercise of the share. You can pay them out along the way if you like, but you can't tie it to the actual exercise of the stock right. Last comment here, there are similar rules for stock appreciation rights, where you aren't actually getting an option to purchase stock, but you do get the option to exercise and receive the difference in the value between the exercise price and the current value of the stock. All right, a few more comments on stock options. Just here I'm going to talk about the fair market value at grant. If it's a public company, well, that's pretty simple. You look to the established securities market, the NASDAQ or NYSE or other established market, to determine the fair market value. If it's a private company, well then the regulations say that you must use the reasonable application of a reasonable valuation method to determine that fair market value. What would be some examples of this? Well, probably one of the best would be an independent appraisal of the company. That would have to be recent. Typically you can't. The longest you'd be able to extend with some type of a value determination or appraisal would be 12 months. And if any circumstances have occurred in the interim, some big change in the business or in sales or something significant, well, then you might need a new appraisal at that point. Other ways could be a formula, certain formula-based valuations. The key here, though, is you don't just want to have a formula that you use for valuing the options. It should have some applicability or use to other areas of the company. In other words, the IRS doesn't want to see making some advantaged valuation or some advantaged formula that works to the benefit of the option on one hand, but then another valuation formula for other purposes. It could be a recent sale of the company or stock would be an excellent determination of fair market value if it is a sale to an independent or a third party. And in any case, the IRS does a facts and circumstances analysis. All right, restricted stock and RSUs. Just briefly, restricted stock, or could be restricted LLC units, these are exempt from Section 409A as the grant of property, but they are subject to the rules of Code Section 83. But it has to be the actual grant of stock that has restrictions on it. On the other hand, if what's granted are restricted stock units, these could be subject to 409A. So what's a RSU? It's a unit payable in stock or cash, and it's going to be subject to 409A if there's any kind of delay in payment between the vesting time and when it actually gets paid out to the employee. Most often you'll see these being exempt from 409A as a short-term deferral, which I'm going to get into more on the next slide, meaning that the RSU is granted, and then as soon as it's vested, well then the person recognizes income on those amounts at the time of vesting. All right, bonuses and LTIPs. So as I said, 409A expanded what was considered deferred compensation, which included expanding it to things like bonuses, incentive payments, long-term incentive programs, or LTIPs. So how does this work? If an annual bonus is earned and vested in 1 year, the 2016 bonus is earned and it's vested, considered vested as of December 31, 2016, but it's not paid until 2017, well then it's going to be non-qualified deferred comp if it's not paid promptly after year end. Similarly, with a long-term incentive program, if that bonus is earned, maybe it's a 3-year program, if that bonus is earned and vested over several years, but paid in a later year, well that could also be non-qualified deferred comp. The key here, as I said, there's a big exception in this instance, and that's the short-term deferral exception. Any amount paid within 2.5 months of the end of the calendar year, or potentially an employer's fiscal year, in which vesting occurs, can be considered exempt from being deferred compensation. So with these type of programs, which is very common, like for example, bonus, one common provision is to simply say, yeah, it's the 2016 bonus, but you're not vested in it until we determine it in early 2017. And once it's determined, let's say it's determined February 15th or March 15th of 2017, then you are vested in that amount, and then we basically have the rest of the year to pay it. So that's one way to address this, similar with LTIPs, where it would pay out immediately after the vesting occurs at the end of year 3. However, if payments are extended, let's say you have an LTIP of a 3-year period, and then the payments either partially vest in year 1 and 2, or along the way, or those payments are extended over a couple years after the end of that performance cycle, well then you will have to comply with these 409A payment requirements or payment restrictions. One thing, I've been using the term vested here during this presentation. In the 409A regulations, it usually uses the term substantial risk of forfeiture, SROF, substantial risk of forfeiture, to refer to vesting. Oh, I had one other note here. Short-term deferral will not apply just because something is paid within that period if the program provides that there could be a later payment, such as paid on separation from service. Maybe you vest and separate from service within a month, but just because that could fall within the short-term deferral period, it doesn't qualify because that separation from service could be 1 or 2 or 3 years from now. So short-term deferral has to be designed that way. You can't fall into it necessarily. Okay, separation, severance pay. This is also another deferred comp or possible deferred compensation component. This could be provided under an employment agreement, separation agreement, severance plan. The payments would typically be non-qualified deferred comp unless paid within the short-term deferral period. An exception though, and there is a big exception provided here. So at first one identified is maybe the severance pay is a short-term deferral. It's paid within a couple months of the termination date, or it's paid in the year of termination. But another big exception is the involuntary separation pay exception. The termination must be involuntary, such as a termination without cause, although a few bullets down I mentioned a good reason termination where someone has been mistreated in a sense, where the employee's circumstances have changed of such where they've effectively been terminated. That can also qualify, and there's a definition in those regulations. But there is a limit on what can be considered involuntary separation pay, and that is the lesser of 2 times the employee's annual rate of pay, or if it's a high earner, someone making significantly more, say $500,000 a year, well then it's limited to 2 times the Section 401A-17 limit. That's a limit that ties to qualified plan compensation limits. That's currently $265 for 2016. The involuntary separation pay must be paid within 2 years, and I already mentioned the good reason definition. Well, one thing I'll mention, release of claims. The IRS has come out and said, hey, it's very common to have separation pay or severance pay conditioned on the employee signing a release of claims. But the IRS was concerned that an employee could manipulate the timing of the payment by delaying the execution of that release. So usually I'll put into an agreement saying something like, well, the severance pay will be paid on the 60th day, provided that employee has turned in the release of claims within 50 days, something like that. And there are rules that the IRS has come out, or guidelines that the IRS has come out with how to handle a release of claims. Okay, separation pay, specified employee. I just mentioned the specified employees, that relates to public companies only. Certain top-level employees, key employees of publicly traded employees or publicly traded companies can apply to any separation pay, anything paid at separation, whether or not the payment is involuntary. And what it does is delay the payment by 6 months after separation. This has to be written into your plan if you're a public company. You can use those short-term deferral and involuntary separation pay exceptions to get some of that money out of the 6-month delay. But this is directly came out of the Enron incident where the IRS didn't want executives pulling their money out shortly before they knew or had a sense that the company was going to go under. Okay. All right, we're on to 409A enforcement. We're just about done here. I think I mentioned this several times. Violation is a 20% excise tax on the participant in addition to immediate taxation on the amounts involved. This is generally identified by the employer, generally identified and reported by the employer. I've rarely ever heard of any instances of this being reported, but that is how the penalty works. There's been limited enforcement by the IRS so far. There was an audit initiative announced in 2014, approximately 50 very large employers. They didn't identify the employers, but they announced the program. Haven't heard a lot after that, but there was a 2015 Chief Counsel memorandum that addressed the idea of correction of errors in a deferred comp arrangement in the year of vesting. It said that was not allowed. But it did recognize that some corrections of these types of these arrangements can be done in prior years. There's only been a handful of court cases so far, but otherwise, to help enforce 409A, and it has been, it was a big process in the first years, in 2007, 8, 9, getting these provisions into place and getting plans updated or modified to fit for 409A. Well, the IRS recognized there could be errors out there in these plans, and we're not going to be able to monitor all of them or audit all of them. So they did come out with 2 correction programs. First was Notice 2008-113. That deals with operational failures. The plan is right, but boy, we didn't carry it out properly in how we were handling the employees' deferred compensation. And then later they came out with Notice 2010-6, which addresses certain document failures or failures in the way the plan is designed. Okay, that about brings us to the end of the presentation. Just some closing thoughts. Review your client's retirement arrangements, incentive plans, employment and separation arrangements to see if 409A applies. Are these arrangements subject to 409A? You don't want the gotcha element to occur. And that has been the case with a number of employers where, well, I didn't realize this was deferred compensation or subject to this statute. So review those arrangements and check to make sure they either comply with 409A or that they are exempt from 409A or fit one of those exemptions I discussed, such as the short-term deferral. Take action to make any available corrections. And finally, just be aware of Section 409A when preparing new arrangements. Oftentimes I'm handed something at my firm, hey, can you take a look at this employment agreement or this severance arrangement? Does 409A have an effect there? And it's just a precaution because some of these are not obvious. It's not obvious in a lot of cases here that 409A would be applicable, and the penalties can be very steep. So thank you very much for the opportunity to speak with you today, and appreciate the Iowa State Bar. Yeah, if there are any questions, we still have a couple minutes here.
There's one.
Oh, let's see here. Right there. Let's see. Are there any other exceptions to the rule that the participant must make the election by December 31 of the year prior to the year in which the compensation is earned? So I did identify that performance-based compensation exception, but really there are no other exceptions. If the amounts to be earned in 2017, you have to make that election before the end of 2016. I hope that addressed that question.